We are just letting the Zoom populate. We will go live at the top of the hour. It's been one of those days, one of those weeks. It's an emu shirt day, which carries deep meaning. The clock has struck 4 and we are live. It is Trump Trials and Tribulations. The date is October 19th, 2023. I am here in my cave, but not the hammock studio, joined by Roger Parloff in the sconce studio, Quinta Jurecic in the, it's my office studio, Hyemin in the actual deforested jungle studio, and Anna Bauer joining us from what room in your palatial mansion is this, Anna?
Well, today I'm calling it Sydney's study because, of course, in honor of Sidney Powell and our discussion that we'll have today about her. But, I just have so many rooms in my palatial mansion that I'm able to,
dedicate this one.
Exactly.
Mm-hmm. I think that's good. We also have a special guest today we're going to start out with Anna Hickey joining us. Anna Hickey, show yourself. Anna Hickey is the person who actually runs Lawfare Live, and she has also been part of the team that has developed a really cool new feature for Lawfare, which is we have unveiled today. And I asked her to come on Lawfare Live and give a little tour of it. So Anna Hickey, why don't you share your screen and show us what you guys built?
Yeah, so my screen should be shared at this point. Let me know if you guys can't see it. But this is something new we launched today. It's the Trump Trials landing page for all of Lawfare's coverage. You can find it if you just scroll down on the Lawfare homepage, click investigate coverage, and then you can very easily see all of our coverage of the Trump trials. You can find the docket watches we have for each of the trials. So if you want to see Sidney Powell's guilty plea, for example, you can go to the docket watch at Fulton County, and then you get to see all of the filings that have been in the 11th Circuit, in the district courts, and in the state court. After that, you can also find the Trump trials at current projects. You can check out Trump Trials and Tribulations on that same page. The Trump Trials calendar that shows upcoming hearings and important filing dates. So on October 23rd, you can see that Chesbro's trial begins. We have to update that because Sidney Powell has pleaded guilty. And you can also find recent Lawfare coverage of the Trump trials at the bottom. And then just to show you what a trial page looks like, this is Trump prosecuted in DC, so it's a January 6th case. You can find all of our analysis of the proceedings, the court dispatches by Roger, Hyemin, Seraphine, Anna, and all of the wonderful Lawfare contributors that head down to the courtrooms to take incredible notes to write these wonderful dispatches. You can find documents here as well, and then there's another docket watch button at the bottom. So that's what we've launched today. We welcome you guys to check it out, and it should be an easy way for everybody to find all of the coverage.
Super, thank you. So this is, as most of you know, this is material that we've been collecting. It has been on the site for since we started, since these cases, but this has been this is an organizational effort that, organizing it and putting it all in one place is actually a really difficult and complicated curation project that Anna and Catherine and Hyemin and Tyler have been working on for quite a while. And I know a lot of you have been asking for a calendar, so we now have a calendar for you. All right, let's start with the day's news. We were in our morning editorial meeting just to set the scene. Anna was driving in an Uber to a meeting with a source, and all of a sudden she bursts in on the conversation and says, Sidney Powell is pleading guilty, gotta jump on YouTube and watch the hearing, bye, and disappears. And so Anna, when you jumped into the hearing, I'm only dramatizing this just a little bit. My favorite line of the hearing was when the prosecutor asked her how old she was, and she responded, oh gosh, I'm 68, notwithstanding my exceedingly youthful appearance. What happened today, and what do you make of it?
I don't think you're dramatizing what happened in our morning meeting at all. That is exactly what happened. And I apologize once again to Anna Hickey, who was in the middle of giving a presentation when I shouted, Sidney Powell is pleading guilty. But so when I joined the hearing, it soon became clear that that is indeed what was going on. Sidney Powell had reached a plea agreement the day before. She had previously been charged with several felony counts in the original indictment, including a RICO charge, and then counts 32 to 37 of the indictment as well were discrete criminal charges against Powell related to the events in Coffee County, Georgia, in which there was an unauthorized access and copying of voting machines in Coffee County. And so in exchange for, pleading guilty, Sidney Powell got those charges reduced down to 6 misdemeanor counts for conspiracy to commit election interference. And in terms of other, conditions of this plea, she must write an apology letter to the citizens of the state of Georgia. Ben, I know that is one of your favorite special conditions that prosecutors have been asking for when they've been reaching these plea agreements with Fulton County defendants. But beyond that, she must also have a $6,000 fine, $2,700 in restitution for replacement of the equipment in Coffee County. And then she gets first offender status, which means that if she abides by all of the conditions of her probation and of her agreement, then she will eventually potentially be able to have these charges kind of erased, so to speak, so that she will be able to say in the future that she has never been convicted of any crimes. And the sentence that was recommended by the prosecution was 6 months of probation. So no jail time for Sidney Powell, it looks like. And then finally, the big thing, and the thing that is really important here, is the fact that Sidney Powell agreed to testify truthfully against co-defendants in this matter, any future proceedings. She also agreed to turn over any documents that are not subject to lawful assertions of privilege that were made in good faith prior to the deal being reached. So it's kind of unclear to me exactly what that means, to what extent she would have had to have raised privilege previously over certain documents. Of course, she has raised attorney-client privilege, for example, in different settings, for example, before the January 6th committee and that kind of thing. So it's unclear to me exactly what the extent of prosecutors' access will be to her documents. But it still is a very big deal. This is not the first defendant to plead guilty in the Fulton County case, but it is the first person who potentially has some really critical knowledge about Trump's inner circle and who was involved in some of those very high level discussions that were going on at the White House, for example. And then, in this period prior to, December of 2020, when a lot of these folks were, talking with Lynn Wood and Mike Flynn and those kinds of folks at this plantation in South Carolina, which was a big subject of investigation by Fulton County prosecutors as this investigation was kind of ongoing for many months with the special purpose grand jury. So I think that's a good summary of what happened, Ben, and hopefully I'm not missing something. But to me, it's a very big deal that this happened, although it's maybe not surprising given the charges and evidence against Sidney Powell.
And the fact that the case was going to jury selection tomorrow.
Right.
So let's talk about a couple of details of this that I don't think have gotten enough attention. One is that the trial starting tomorrow is happening anyway, because while Sidney Powell has pled out, the estimable Ken Chesebro has not. As far as we know, was Chesebro offered a similar deal, and what happened?
Right. So, we do know that Chesebro was offered a deal earlier this month. It was rejected. ABC first reported this yesterday, and I can confirm that, that is, in fact, the case, that he rejected a plea deal. I think that it's unclear right now what exactly happened and what the circumstances were around that rejection. But, if I had to speculate, I would say that, Chesebro and Powell, they're both people, right, who have significant exposure at the federal level. Sidney Powell and Ken Chesebro are both two of the unindicted co-conspirators who were mentioned in the federal indictment brought against Trump for election interference. And I think that probably something that could be going on here is that maybe there's some hesitation by some of the defendants who have risk of criminal exposure at the federal level to accept a state level deal that maybe isn't coextensive with what's going on in Jack Smith's investigation. So I think that that's part of the calculus. I also think too that Chesebro, as opposed to Powell, certainly has a stronger case in terms of, thinking that there's, more arguments that a jury might be able to latch on to, because the facts there are pretty much, if you look at the case against Chesebro, it's kind of like the prosecution and the defense are probably going to agree on a lot of those facts. And it really just comes down to the question of unlawful intent. Right. And, that's exactly the conversation that we had with Chesebro's attorneys when they came on the podcast is, that this question of intent is crucial. Whereas with Powell, it's very different. It seems like, the case there was just much more solid.
Well, and also it's a smash and grab job. I mean, she's alleged to have organized effectively a break-in and theft of a bunch of stuff. And, her name is on the check. Her name is on the contract. She had a real problem. I'm still a little surprised Chesebro hasn't pled out yet, but I suppose there's time for that before the hearing tomorrow, before jury selection starts tomorrow.
Yeah, and also, there's still time, even if jury selection starts, it's possible that they could reach an agreement even, after jury selection starts. So maybe it's something that they're considering. I'm not sure if it is, especially after today, but you would have to think that Sidney Powell's plea agreement would really have them thinking about that. So I'm very much going to be keeping my eye on the docket and on Judge McAfee's YouTube channel to see what happens here in the next few days, because this does feel very different from Scott Hall's plea agreement, which we all thought was a big deal, knowing kind of the many different elements of the alleged RICO conspiracy that Scott Hall could have been involved in. But I think that, Sidney Powell, it's just a whole other level of, her involvement and knowledge. So I will be a little bit surprised if there's not a lot of these defendants who aren't Ken Chesbro who are considering, going for a plea right now.
Right. You don't want to be last on the plea bus.
Mm-hmm.
All right. Next question. One thing she has to do to make this plea is waive her Fifth Amendment rights, because she's got to testify now against, I guess it's 16 remaining co-defendants, 17 remaining co-defendants. And she's got to answer questions. She still has exposure at the federal level where she is an indicted co-conspirator number X, I think 4, but she must be expecting an indictment. Do you think, have you heard any indication that maybe this means she has some understanding with federal prosecutors, or is this a kind of roll the dice and resolve the state case and figure you'll deal with the feds later?
I don't know the answer to that question. I am still trying to figure that out. So I don't know the answer, but especially with how concrete this evidence seemed to be against Sidney Powell, and especially knowing recent reporting that the special counsel has been more interested in these voting machine breaches, I would really have to wonder, and I would be very surprised if her counsel had not at least tried to get some kind of coextensive agreement. But these are investigations that are on different tracks, and so I just really can't say. And it may be something where Jack Smith doesn't feel that he, needs to have an agreement with Sidney Powell, because he's going to do what he's going to do. And every public indication has been that Fani Willis and Jack Smith are not working together. So I really am not sure. It may just be a roll of the dice, and she's hoping that she will be valuable for Jack Smith when the time comes, and if it does come, for federal prosecutors to come to them and say, let's make a deal. But I'd be curious to hear what everyone else thinks, because I'm not sure.
Yeah. So does anybody else have thoughts on this? For Rafferty to let her plead, knowing that she's got to waive her Fifth Amendment rights, that she's got to testify on a whole lot of matters in which she presumably has federal exposure in an already indicted case in which she's named as an unindicted co-conspirator. Roger, what do you think the logic of that is?
Well, I'm afraid I've been sort of in my silos, and I don't think I can add to what Anna said. I'm a little too far away from it.
Quinta or Hyemin, do either of you have thoughts on this?
Yeah, just one quick thought. I mean, so I've obviously been following this less closely than Anna, but I will say I was really surprised when Powell pleaded, actually. I mean, if you kind of abstract out, it makes a great deal of sense for her to plead, but I think you can kind of separate the Trump defendants into categories of people who have taken a kind of defiant, never surrender, you can take my life, but you'll never take my freedom approach. And the people who have just kind of decided to cut their losses and have not been, so loud publicly, for example. And Powell, I guess, has definitely been quiet recently, but before this, I would have put her pretty firmly in the former category. And what makes me say that is that I've been following her various bar discipline cases. She now has 2 against her in different states, which is kind of unusual, as well as sanctions levied against her by a Michigan judge. And in her filings appealing those sanctions and objecting to the ethics charges against her. She has consistently over the last year or so been very defiant, has not backed down from her claims about election fraud. I don't know if she's actually said the election was stolen, but she's really doubled down on the idea that there were, indications of irregularities that were concerning, not admitting that she did anything wrong and relying on these kind of really crazy affidavits of people who were claiming they'd seen wrongdoing. And so she really seemed to be sticking to her guns. And in that sense, I was quite surprised to see her plea. And that makes me wonder whether there might be, if she's decided that it's really time to kind of change tactics, that perhaps that might indicate that there are conversations going on with Jack Smith's team as well. I don't know. But I do think that's kind of useful context maybe for at least framing the discussion here a bit.
Yeah, nothing concentrates the mind like a hanging. I will just say on this point that there is no way the feds let her plead to a misdemeanor. And I think you don't resolve this case on the basis of a plea unless you also at least have an understanding that you're going to have to plead out at the federal level as well, because when this case goes to trial, you're going to have to answer questions that are going to implicate you. And so I think take this as an indication that she intends to reach a plea deal with Jack Smith. And that will, I think federal policy is pretty clear that you don't plead out a case like that to a misdemeanor. So look for at least one significant felony plea. At least I would expect that. Jacob, you have a question. You got to unmute
I accidentally
yourself
raised
for the
my
question.
hand.
You
incidentally.
accidentally raised your hand.
I do have a question, but I'll save it for the end.
You better ask it then.
All right, here's my
sometimes-
question.
Sometimes God causes us to accidentally raise our hands
But-
because we have awesome questions.
Well, let's. So I've had the over under at 10 for pleas in the Georgia case. I was curious who would take the over or the under in that case.
Ooh, great question. I would take the over on that. I think you're going to have an increasing rolling stone gathering no moss as it heads down the hill. The more people plead, the more people are going to plead. But we're at 2 right now. What do you think, Anna?
I mean, I think, yeah, I think maybe over, but I really just can't, I don't know. At this point, I'm with you, Ben, but I reserve the right to change my mind.
I bet we're going to get one more within the next 24
Mhm.
hours, maybe 2 more. I think you're gonna, the first horse that leaves the barn, it doesn't look like a stampede, but you don't want to be the last person to take the plea in this. The deal gets worse and worse as you go. Yes, Roger.
Yeah, listening to Anna describe the plea, I was surprised just how, it's sort of like an offer you can't refuse. It's so light, what she's being offered on its face. It's misdemeanors that go away eventually. It's like you said, it's a first offender sort of thing. It's sort of hard to, if she's hoping to win her bar proceedings, this would, keep her in the bar. It's very attractive. If they're going to offer deals like that, they will get more than 10.
Yeah, look, they've put out, I think they are, particularly given the disparity between the amount of time you can get if you go to trial and lose and the relative generosity of this deal. Although 6 years of probation is not trivial just because it's a long period of time, but it is probation and it's not a felony plea. But I agree. I think as long as that deal's on the table for some of these people, it's too attractive to pass up, except for Ken Chesborough, who, as Quinta says, does seem to be having the freedom thing with the Mel Gibson thing going. So I would still take the over on 10. All right. We have one other question that we should which is Josh asks, how does the plea affect federal cases? I think we've answered that, which is that it, first of all, mostly affects her federal case, assuming there is one, which I assume there will be. But of course, her testimony could be significant in the federal case against Trump as well. Remember, she was present at that famous December 18th meeting at the White House, where they discussed declaring martial law and seizing voting machines and all that jazz. And so I think it could affect, it potentially affects her case very much, but I think it could also affect the larger discussion. All right, let's turn to Judge Tanya Chutkan in the U.S. District Court for the District of Columbia, who imposed a gag order this week. And I want to start by saying that I apologize for last week's use of a paper gag, which ripped. Today we are using a full shirt gag, which will not rip. Hyemin, you were there. Walk us through what happened.
Wow, Ben. I don't know if I can do that while watching you with the gag in your mouth, but yeah, so Judge Tanya Chutkan heard from Trump's lawyers and the government about whether to accept the government's motion to have a gag order on what Trump can say during the trial. And the reason why the government wanted this was because they think that his Truth Social posts and other interviews have kind of ended up intimidating witnesses or could intimidate witnesses. And they want to make sure that the trial can proceed without there being a tainting of the jury pool. And the government's overall argument was that, look, this is not them trying to infringe on Trump's rights as a candidate. They're not trying to gag him insofar as he can't exercise his First Amendment rights to talk about his candidacy, but it's more about this narrow, we don't want to be putting people on blast who might need to end up taking the stand and give testimony. So that was the government's main argument. And then the Trump side of things was this is just another one of the special counsels trying to silence Trump and not give him the opportunity to really have a fair campaign. And it kind of feeds into their overall Trump stance that this whole prosecution, of course, has been politically motivated and that the whole thing top to bottom is this kind of conspiracy. So those were the kind of two sides, and we can definitely get into the details on everything. But there were a lot of interesting moments where Judge Chutkan really tried to tease out exactly what the gag order was going to look like. And I thought that was really interesting because we got into very granular examples of what can you say and can you not say. And I think that by the end, she had a clear vision of what she wanted to allow Trump to be able to say in a way that got much more narrow than, for instance, what the original motion from the government said. So she definitely had a professorial kind of ambience, and she was very, very, very critical. And I think she did a great job of really trying to get to the bottom of exactly what the government wanted to see and exactly what Trump's concerns were.
So in your piece about it, you portrayed Trump's lawyer, Lauro, as, sort of flamboyantly making points that Judge Chutkan kept kind of reminding him did not appear to be directed at her. How do you understand, first of all, what was Lauro doing that prompted that? And secondly, how do you understand the dynamic between the two of them?
Yeah, well, so I want to start by saying that I thought Lauro was quite effective overall. I had seen him in the prior hearing for the trial date setting, and at that point, I thought he was, pardon me, but a little bit whiny and just kind of like asking for leniency about, we need time to go through all these documents, and so he had clearly even then kind of a way of having this kind of rapport with Judge Chutkan that I thought was interesting, but less effective then. This time, I thought he was pretty quick on his feet and was able to banter back and forth with Judge Chutkan. And so what he was doing, Ben, in answer to your question, was trying to point out, these are things that any presidential candidate should be able to say, and Trump should, for instance, be able to talk about why DC is a terrible city if he thinks that DC needs to be better managed, quote unquote, or if he wants to talk about what he perceives to have been a Justice Department that was weaponized against him, then he should be able to say something like that. So he kind of started to get into, again, the similar kinds of rhetoric we've heard from the campaign. And so for Judge Chutkan, it kind of blurred the lines of, are you talking to me, or are you trying to get a message out about what, the Trump campaign has been at its core? And so she had to kind of be like, just to be clear, there are certain there are things that can be distinguished here. Like you can say that DC needs to get rid of its rats, for example, which it does. But you don't need to say something like that targets the Biden administration, for instance, so head on, and then like kind of create inferences about because Biden is corrupt and this whole thing is corrupt and like Jack Smith and the rest of everyone are thugs. So I think that's where she definitely had a lot of back and forth and had to remind him a number of times, this isn't campaign rhetoric time. This is what exactly is the problem with certain things that Trump could say that could actually lead to people not wanting to say or take the stand for fear of reprisal or for fear of like violence to their life.
And was your impression that when she was saying to him, your audience for that statement doesn't appear to be me, what she was saying is you're saying the things that that the client wants you to say, or was she saying that you're delivering campaign rhetoric? In other words, was the audience Trump or was the audience potential voters? Not that she said, but what do you think she was accusing him of there?
That's really, really hard. I mean, I think that in some ways she probably was suggesting that he was saying things that would have made Trump proud and like what Trump would have wanted to hear his lawyer say. But again, the lines are so blurred between what Trump himself says and what he wants the voters to hear. And so it kind of almost becomes the same thing in some ways. So that was my sense. I don't know, it would be great to ask her exactly what she meant, but I mean, she used the term campaign rhetoric a number of times to just say, don't bring that here. But again, if your campaign is in part on kind of sowing this idea that the locuses of power are corrupt and that you need to kind of fight back against the state and stuff, I feel like what Lauro is trying to defend Trump's right to be able to say ends up becoming the same thing there. So I don't know if that's an answer to your question, but I think the answer is that it's very blurry. And so then that's why she ended up going to the hypotheticals in the end to try and narrow the question exactly about the campaign.
So Roger and Anna, you both were there as well. Do either of you have a sense of of what you think the answer to that question is? Is this a situation where she's saying, I know you're talking to the client right now, not to me, but I want to hear your arguments to me? Or is she saying, this isn't a frickin' campaign ad, guys?
Well, I agree with Hyemin that it's really sort of one and the same thing. It's what Trump wants to hear because Trump is on message as far as the campaign goes. So I thought, Trump wants to say over and over, the Biden administration is silencing me. The Biden administration is persecuting me. And he was trying to say that. And that's both, his id and it's his campaign message. So it's one and the same.
Gotcha. All right. So Roger, what did she end up ruling? There's been a lot of gag order press, but what is the substance of the gag order?
It's interesting. I think it was shrewd. She divided the government's request into 5 rough categories. And she granted 3 and denied 2. The first category was statements about the District of Columbia and jurors indirectly, because he was making tweets sort of along the line. He was calling DC filthy, crime-ridden embarrassment to the country. And she decided not to restrict those. Her theory was that I have jury selection. I will go through the process. I can weed out people that are offended by that. She did hint that she knows coming down the line, they're going to ask for a motion to change venue. And she hinted that that's going to come back to bite him in the butt. That, if you're insulting the jury and then you're saying, well, I need to go away because they're biased against me, you've sort of created your own, you've tried to exacerbate the problem yourself. And it's sort of like, the old line about the guy that shoots his parents and then says, I'm an orphan, I think she's going there. The second category were statements against Biden, like crooked Joe Biden and the Department of Justice, the Department of Injustice in a lot of his tweets. And also the idea that the Biden administration, that the prosecution is politically motivated. And that, it's Biden that is manipulating everything. She's not going to stop that either. She said that Biden is fair game. He's not even a party. Even the government said that. The Biden, even the special prosecutor, Department of Justice, that's not really a party. And also, as far as this notion, I think the government special prosecutor did want to stop him from saying, this is all Joe Biden bringing this prosecution. It's not true. She said, there are, I can't rule that out to a mathematical certainty. And also she quoted a line from, there's a Supreme Court case, very important here, called Gentile versus State Bar of Nevada, or maybe Gentili. And there was a line in there. It's not, I don't think it's a majority, but 4 of the 9 justices were saying, criticizing the exercise of state power, which is what a prosecution, criminal prosecution is core First Amendment stuff. So if this is your theory of the case, that this is a, politically motivated prosecution, she's not going to stop that. So I thought that was very smart and shrewd. The other categories were attacking the prosecutors, their staffs, and their families. And she said, that's off. This is stuff like deranged Jack Smith and thugs. She calls them thugs. And the point is not that these are mean or, crude or insulting. She made it clear. She mentioned twice this famous line from Henry II, will no one rid me of this meddlesome priest? You know, and then shortly after that, the knights go out and they murder Thomas Becket, the Archbishop of Canterbury. And that's what she's saying is happening here. This guy, he calls people thugs, and it means somebody needs to get rid of the thugs. And it's not just, she's not speculating, there's a record, and the government presented a record. Some of it's under seal, but some of it's, you know, available. And we know what happened to Ruby Freeman. You know, we know what happened to Brad Raffensperger and his wife. And so, you know, he says these things, and the more unstable among his, you know, followers do act. And they say they harass and they intimidate and they make threats of bodily harm. And no one is allowed to do that. And she doesn't care if this is a presidential election. She's not going to permit that. So that was out. Then the fourth category was court personnel and families. This, of course, she's not including herself.
Yeah, I thought that was actually really classy of her
Yeah.
to leave out herself. She gets martial protection, court staff don't. She's the accountable actor. And I think just saying, like, we're not talking, you can say whatever you want about me, but leave the bailiff out of it.
Exactly.
was a smart move and actually a classy move.
Classy move. And none of that is, you know, hypothetical stuff. Obviously, you know, Justice Arthur Engeron's clerk was targeted by Trump, you know, Schumer's boyfriend or girlfriend. And of course, Judge Chutkan got this racist death threat for which somebody is being prosecuted in Abigail Shree, I think, in Texas. So anyway, I thought that was classy, like you say. And then the last category were witnesses. What they're going to, you know, discussion of expected witnesses, expected testimony, their credibility, that's out. And now, so all of that I thought was very, very sharp. The one thing that surprised me was, you know, the next day when the actual written ruling came out, it was very short, and there were some things it did not include, you know, what the government's language they had proposed would incorporate, you know, one of the magic words from Gentile, like things that cause substantial likelihood of material prejudice, and they're about witnesses and this and that and that. She dispensed with that. She said, it's very short. It says, all interested parties in this matter, including the parties and their counsel, are prohibited from making any public statements or directing others to make any public statements that target, and then the categories, the special counsel, you know, and his staff, the defense counsel and staff, any other, you know, and so on. That word target is a little confusing to me. Does it mean reference, or does it have to be derogatory, inflammatory, and intimidating, which is another phrase that the government had used? So that's a little surprising. Another thing that was a little surprising was in the body of the order, she used the language she found as a fact that what he was doing, these statements were causing, quote, a significant and immediate risk of intimidation and so on. That's not the language that I've seen in court rulings. Maybe I haven't seen all the court rulings. You know, I've seen one level, which is that one I mentioned, substantial likelihood of material prejudice. The other is the clear and present danger standard, the highest. And so she said a significant and immediate risk. I don't know if there's case law on that, but I think I was a little, it seems safer to use something that's tried and true, but maybe I'm just missing some controlling DC precedent.
Okay, so that actually brings us very neatly to Moralee's question. Sir, the floor is yours.
Yeah, so the gag order is a restraint of speech, First Amendment, blah, blah, blah. Is this subject to interlocutory appeal? And if so, what do you all think? How do you think the DC Circuit and Supreme Court will go? Or if it's not subject to appeal until after a verdict, is there grounds here, potential grounds here for setting aside the verdict if the restraint of speech is found to be unconstitutional?
Yeah, so the things you've covered up in the blah, blah, blah there are actually worth exposing. So let me, for those for whom the blah, blah, blah covered up the explanatory material, let me clarify. Normally, you can preempt all kinds of standing requirements by claiming that something is a restraint on speech, and First Amendment chills can be a basis for pre-enforcement challenges that would normally not be justiciable yet. And so this question is a very ripe one. I will take only the last part of it, which is that it is almost certainly not the case that you would set aside a jury verdict because of an unrelated or because of a First Amendment violation within the context of the trial. But Roger and Quinta, I know you have both thought about this question a little bit. Is this subject to interlocutory appeal? And are we going to see a quick appeal?
He's already appealed.
So yes and yes.
Yeah, so that makes my task easy on answering that. I believe there is an interlocutory appeal, but I don't believe there would be any basis for asking for a stay. I don't think it will stall the case. There's no, there would be no reason. But that's an independent thing. So I'm not worried about it in that respect.
Quinta, you mentioned that you were also had seen some concerns about the use of the word target in the order. How do you think that's going to fly in front of the DC Circuit?
Yeah, so I'll say I am not super familiar with the doctrine here, so I'm not going to weigh in on my own read of the situation, but I will say that I've seen Ken White, better known as Popat, on Blue Sky suggesting that use of the word target is perhaps overly vague. Ken does defense work and usually takes a pretty strong view of the First Amendment. But I think that it's worth keeping that in mind. But I certainly, it's potentially open to criticism along those lines. I also noted that I believe Charlie Savage's write-up, Charlie Savage and Alan Foyer's write-up in the New York Times also noted along the lines of what Roger was saying, concerns that target is potentially vague, and that it doesn't just include statements that are disparaging, inflammatory, or intimidating, which is what the government had asked for. So that Times article doesn't go any further or cite specific objections or specific folks who have raised potential objections, but I think the fact that it's showing up in this Times overview suggests that there's some murmurs of potential discontent there. So it will be certainly interesting to see what the DC Circuit does with it. We haven't gotten any briefing about it. Trump just filed the notice of appeal, I think yesterday or Tuesday. So it's early days yet.
One thing is, of course, you could easily imagine the government, if it's worried about this point and doesn't want to defend it on appeal, simply moving Judge Chutkan to narrow the order to speech that is inflammatory, disparaging, tends to provoke violence, etc. And she can she is not losing jurisdiction over this case. So, all right. So, Quinta, speaking of Judge Chutkan, you have a lengthy piece this week on the motion before her to dismiss the entire case on grounds of presidential immunity. This is a matter that we have spoken about both of the past 2 weeks. We're going to be speaking about it for each of the next several, I suspect. I think the government's response is due presently. I mean to read this briefing extremely carefully. You have tied it to a very long-running interest of both yours and mine, which is the relationship between the person of the president and the institution of the presidency, as reflected in the oath of office and as embodied in the medieval theological conception of the king as having two bodies. So, give us the unified field theory, king's two bodies, presidential immunity from criminal prosecution, post-presidency, oath of office. What's it all got to do with one another?
Yeah, so that was a real wind-up right there.
Let it never be said I don't know how to do an introduction for one of my people.
Yeah, that was it's a greatest hits tour, really, of everything that I've written on Lawfare for the last few years. So what I'm writing about here, this idea of the king's two bodies, as you say, comes from the historian Ernst Kantorowicz's writing about what he called medieval political theology. And the idea is essentially that the medieval king there's the body politic, which is sort of the institution of the monarchy that persists across the lives of individual kings. So that's the body natural. And I had argued in a piece that was maybe more serious than it quite let on early on in the Trump administration, that Trump's at Real Donald Trump and at POTUS Twitter accounts were the king's two Twitter accounts. The Twitter natural and the Twitter politic, one might say. And there's been some really interesting work done in a more serious vein on this topic by Daphne Renan, who wrote a really great law review article about it, essentially arguing that this sort of tension between the institutional presidency and the figure of the particular person who happens to be occupying it is something that is really present in conceptions of the presidency since the founding, and sort of resonates throughout it. And what I'm trying to argue here is essentially that, Trump really brings to the fore a lot of those tensions that Daphne identifies, in the sense that he at points magnifies the distinction between the body politic and the body natural by sort of trying to, just appearing, unpresidential or modern day presidential, as he sometimes called it, with his coarseness, his unusual approach to the office. There's sort of a gap between the man and office, but then at other times he sort of tries to collapse it entirely and argue that, he's justified in using presidential powers for personal ends. Or in the case of this motion to dismiss, that the sort of the shield of presidential immunity, as described in Nixon v. Fitzgerald, should shield him from criminal accountability for even actions that were arguably an abuse of his office. He doesn't say that last part, that's me. And so that this motion, which is also, as we talked about last time, trying to extend this idea of presidential immunity from the civil context in which the Supreme Court has established that it does exist to the criminal context, which is sort of untrodden ground, is really stating very directly this kind of question that I think various legal institutions and commentators, Ben, you and I included, have faced over the course of the Trump administration, of not only how do we define the difference between these sort of two bodies, but how do you systematically draw a line Because it can seem very easy to say, well, of course he shouldn't be immune for such and such action, but drawing that line in a systematic way can actually be really difficult, to make sure that it's not going to potentially infringe on future presidential action. I would argue, and I didn't quite get to this in the piece, but that the actions on January 6th are so extreme and so far outside of the scope of what we want presidents to do that it's actually less hard to make that argument than it would have been in other instances, like Trump firing FBI Director James Comey, for example. But I think precisely because it has been so difficult for various institutions, from the Supreme Court in the trial ban cases to Special Counsel Robert Mueller, to lower courts, to kind of draw that dividing line, it's going to be really, really interesting to see when we finally get the special counsel's response, just how they make that argument. And as you say, if I have done the math right, which is not a sure thing, I believe that their opposition is due today. So hopefully we should be getting that soon.
All right. We are going to go to audience questions. There's a lot of them, so I'm closing the questions now so that we have a chance of getting through them. We're going to start with Nathan's question, who wants me to read it. What leaders in history or fiction remind you of Trump more than anybody else? So actually what we're going to do with this question, because this is a hard question to answer on the fly, we're going to come back to this question at the end so that everybody has a good chance to think of what who is the leader in history or fiction that most reminds you of Trump. And we're going to come back to it at the end. And I'm going to demand an answer from everybody. In the meantime, Jonathan Cedarbaum, who should be on this panel, not asking questions of it, the floor is yours. But you got to unmute yourself.
Hi.
Hey, Jonathan, how are you?
Okay.
So for those who don't know Jonathan, Jonathan has been the head of the Office of Legal Counsel at the Justice Department. More recently, he was the legal advisor to the National Security Council in the White House. He is a major league national security lawyer and friend, a dear friend of the site, and the floor is yours, sir.
Thank you so much. I only pay Ben a small commission for those marketing efforts. I think I had submitted, I apologize, I think I had submitted a question earlier when we were talking about Sidney Powell. And yes, it was just a question about her law licenses. And the question was whether the guilty pleas to the misdemeanors by themselves would jeopardize her law license or law license.
I believe, so this is actually a complicated question, and I'm gonna say what I know about it and then see what Anna knows about it and then turn it over to Quinta, who's been following the Sidney Powell disciplinary proceedings. But so first of all, I think there was an explicit part of the plea agreement that said this was not a crime of moral turpitude. And I think that was a specific effort to make clear that it does not threaten her law license. That said, her law license is, that may be an academic point because her law license is, I think, toast for other reasons that Quinta can go into. But Anna, am I right about the plea deal and the significance of the not a crime of moral turpitude language?
Yeah, I think that's right. I mean, crimes of moral turpitude can also be relevant for immigration purposes, but that's not a concern with Sidney Powell because, as far as
because
I'm aware,
though an alien, it's not that she's from another country, it's that she's from another planet.
Right, exactly. And we saw the same thing happen with Scott Hall's plea deal, where they specified that the crimes to which he pleaded to were not crime or were not considered crimes of moral turpitude. And the reason for that in his context was not because he's an attorney, but because it has to do with his bail bondsman license. So I think that for any of these folks who are attorneys, whether that's Chesbrough or Ray Smith or Bob Cheeley, all of these attorneys who are concerned about their bar licenses, we would probably see something very similar. And I think that's exactly what was going on there, Ben, with that moral turpitude question. I know a lot of people had questions about that, so hopefully that clears it up.
Yeah, and I take it the point is that not that the state of Georgia or the Fulton County DA's office is protecting her from bar discipline, but it's simply saying we're not going to make it worse. You're on your own on that. Is that fair? Okay, so Quinta, if Sidney Powell is on her own in the bar discipline department and Georgia isn't going to make it worse, how fucked is she?
Well, I don't know if I would put it in quite those terms. I should say I did look up the rules for the Texas bar and confirm that yes. So crimes of moral turpitude subject a lawyer to compulsory discipline, and so this is not in that category. There are a number of other crimes that can also subject a lawyer to compulsory discipline, but I don't believe that any of the crimes for which she's pleaded guilty are in that category. It does say that if a criminal conviction of a serious or intentional crime is at issue, then there is compulsory discipline. I don't know how Texas defines a serious or intentional crime, so I guess we'll see. In terms of where Powell's various disciplinary proceedings are at, so she is in the somewhat unusual position of actually being subject to 2 disciplinary proceedings in 2 different states from 2 different state bars at the same time.
And how does one do that, given that she is not a member of more than 2?
She's a busy woman. So she is barred in Texas. The Texas State Bar brought charges against her. I'm not quite sure when, but that has been going on for quite a while. And this is over her role in the Kraken litigation. I don't actually have the charges in front of me right now. But it has to do essentially with the fact that she's filing a ton of litigation on basically completely frivolous claims. And in one instance, I think allegedly doctored an exhibit as well. So there's a Texas case that is in a bit of a weird situation where it was thrown out by the judge because the Texas bar mislabeled the exhibits in its filing. And then the judge refused to reconsider that. So it is now on appeal, whether or not that not her, the final decision, but just whether or not this should be thrown out because of the mislabeled exhibits. I just checked the docket in the Texas appeals court, and it seems like a briefing was filed in late September, and that there will not be an oral argument. I'm not sure how quickly Texas appeals courts move, but we'll see. And then there is this Michigan case. So yes, typically you are not disciplined by a bar of a state in which you are not barred. The Michigan bar is arguing that because Sidney Powell filed Kraken litigation in that state, that she has essentially brought herself within their jurisdiction and that they are bringing bar charges against her and a number of the other Kraken lawyers on the Michigan case. Powell is pretty unsurprisingly arguing that they don't have jurisdiction over her. I just checked the Michigan bar's website, and it doesn't seem like they have updated their list of filings since midsummer. That doesn't necessarily mean that nothing has been happening. It just means that nobody updated the website. So I'm not 100% sure where that stands. All of which is to say is that Sidney Powell is certainly still facing these proceedings, although because of the weirdness of the jurisdictional question in Michigan, and then this sort of procedural screw up by the Texas bar, I actually think that her bar license might be in better shape than you initially suggested.
Interesting. Okay. Remember, however, that she is still facing potential major federal charges. And it is possible that bar discipline is being kind of held in abeyance for some of that. We have two questions from Antti, our estimable Finland bureau. Antti, the floor is yours.
Thanks, Ben. So do you foresee any changes in defensive strategy on part of the Trump team in light of the Sidney Powell plea and any pleas that would follow it? And could you briefly run down the NBC's motion in DC trial to have it televised, and what's the potential impact of that? Thank you.
All right, who wants to take either of those questions?
Well, I'll take NBC, but Anna, do you want to go at the other one first?
I don't think that their only strategy in the federal cases is delay. And Trump is never going to plea out to any of these charges. I doubt that the federal cases that they would want to let him plea to anything. So I just don't really see how, even if in these state cases people are pleading, like, it's not going to change their strategy, because their only strategy really, I think, is delay. But I would be curious to see what everyone else thinks.
I'm a little, maybe I'm cynical, but there were a lot of guilty pleas in the Proud Boys case. This is maybe comparing apples to oranges, and a lot of those people never testified, and they signed cooperation agreements. And, it turns out, they were not, I assume, I mean, no explanation is given, but you hear stuff, and they're very recalcitrant people, and how much credibility does somebody like, Sidney Powell have at this point? So I don't put a lot of credence in this changing everything. Now, what I don't have as good an idea as you, Anna, about exactly what was going to come in here, because the Coffee County stuff, to the extent you can isolate that, that's really not, the core of the DC indictment. So I don't, but I'm not sanguine about the idea that she's going to blow everybody out of the water, with some big cooperation agreement.
I agree. I agree with you both, actually. I don't think Trump has a strategy for trial except to throw up a lot of dust. And I don't think his strategy is to prevent trial, not to, or to delay trial, not to actually discredit, like not to actually contest the charges meaningfully. And I also don't think he's in a position that she materially changes things, except maybe by giving some color, because as a number of questions we have coming point out, she's a bit of a nut, and she's going to be a very difficult cross-examination for any side that puts her on in a litigation. So I do think having her tell you what she knows about what happened in certain meetings about certain interactions with people that she may have had may be very useful as a factual matter, but I doubt she's going to testify, at least not on anything that's really important.
Well, and I agree with you on that, and this does go to some of the questions we have coming. But I will also say that I think a big question is this question of what documents she has that she can turn over that maybe were not received by the January 6th committee, that have not been received maybe by federal investigators. Like the documentation question is a big one that could be really interesting to see, maybe some of these communications that she has not previously turned over that she potentially now will. And she can authenticate those documents and that kind of thing, and do things that don't necessarily go to her credibility as a witness who has perceived things in the world and listened to conversations, but just has documentation and then, like you said, can speak to investigators, off the witness stand and provide them with information that they can then go and find things out about independent of Sidney Powell.
Right. Look for her, and this maybe answers some of the existing questions. I think the value of Sidney Powell is what she can tell investigators, not what she can be presented to as evidence of to a jury. She is, the cross-examination would begin with where did the phrase "release the Kraken" come from? And it would get weirder from there. And so I really think that's don't look for the blockbuster Sidney Powell testimony. On the other hand, if you want to understand the relationship between Sullivan Strickler and Michigan and Coffee County and the Kraken litigation and testimony before 3 or 4 state legislatures, she can probably tell you some things you don't know. All right, question from Aaron.
Oh, there was the NBC question.
Yes. So go ahead, Roger.
So, NBC, and also before NBC, there was a similar application from the Press Coalition, which is a group of big media companies. And they're partly, there's this Federal Rule of Criminal Procedure 53 that says you can't take photos or broadcast from the court. And so one argument is that a First Amendment argument that's unconstitutional. That's a long shot. And then one argument is that Rule 53, it's sort of a textualist lawyer argument that, well, what if we relayed it from the courtroom to our studio and then broadcast it from the studio? It doesn't violate.
Can I just say, I love that argument.
Yeah. I think that's a long shot as well. Although, I have to say the NBC brief is over 40 pages and I haven't gotten through it. So maybe there's something that will bowl me over eventually. But I think we have to consider them both long shots.
Yeah, I would just say this is a longstanding federal court rule. It's not like it's never been tested before. And the explanation, but we really want to, is not one that I think the federal courts are likely to look with a friendly eye on.
Oh, and one other thing, just the DOJ will oppose it. And incidentally, it's the DOJ, not the special counsel. And I think they sort of have, generally they always try to defend almost always try to defend the constitutionality of federal statutes, and the federal rules of criminal procedure have the status of statutes.
Right. All right. So Aaron asks, if Trump were to be convicted and imprisoned, what steps should the Justice Department take to ensure the public's trust particularly in light of prevalent conspiracy theories among Trump's followers. You know, I don't know that there's a simple answer to this question. Extreme transparency would be the start. You want there to be as few questions that don't have clear answers as possible. You would want there to be a fairly clear answer if he were still a presidential candidate at that point to the question of what are the rules for federal prisoners who are also major party presidential candidates. That's a situation that we've never faced before and never even faced a version of until since Eugene Debs ran for president from federal prison in Georgia in 1920. You know, and then the third is you're going to want some way of making sure that people have as much access to the evidence as they humanly can possibly have without you know, releasing video, which is of course not allowed. See previous conversation about of the trial itself. Does anybody have anything to add to that?
Just that it's completely hopeless. You will never get anywhere. You know, look, the JFK assassination is not solved. You know, for RFK's isn't solved. You know, nothing is ever solved. You know, with the conspiracy group.
On the other hand, I do want to make encouraging words about this. Roger and I are old enough to remember and have been working for an organization affiliated with Court TV at the time of the OJ prosecution. And after the OJ Simpson prosecution, which was the last trial of anything like this spectacle, a very large percentage of surveyed African Americans believed that OJ was innocent and believed that there was a conspiracy. You know, nobody surveys that question anymore, but I don't think that's true anymore. And I do think that sometimes when a conspiracy theory, sometimes conspiracy theories do die down and go away. And the interesting thing about that is that the judicial proceeding in that case, of course, acquitted OJ. And so at some level sort of validated the conspiracy theory, and yet it went away anyway. So I agree with Roger that it's totally hopeless, but, you know, keep hope alive, man.
One other thing, just, you know, what would be really great if you can't broadcast this thing, I mean, you ought to be able to tape it just for history's sake. I think I saw somebody else recommending, but I mean, this is such a historical document, and eventually it needs to be out there.
That's a really interesting point, and I don't think does violate the rules if it were ordered by the court. Okay, we gotta pick up the pace and go through these questions relatively quickly. So quick questions, quick answers. John Hawkinson, the floor is yours.
Thanks, Ben. Can I just flag my note in the chat about Jeff Clark having had a bar disciplinary pre-hearing this morning? I don't know if anyone caught it. I did not appreciably. I assume nothing to say on that.
I saw that it was happening, but didn't have a chance to watch, unfortunately. So no.
I think it was principally about whether his being indicted in Fulton County would affect, you know, should allow them to delay the bar proceeding. And it was taken under advisement, but I don't know the arguments. So my actual question was, it seems to me that Ken Chesebro will really appreciate Sidney Powell having pleaded out and removed herself from his case since she's a whack job. And it makes me wonder if he encouraged it. But by the same token, doesn't the Fulton DA now have a harder time against Chesebro? And that's something they'd surely be aware of. So they ought to have been even more reluctant to offer this plea deal that would facially seem to give her pretty low penalties. So how do we analyze that? And maybe there's a prosecutorial ethics question in there. I don't know.
All right, so I will give a couple quick thoughts on this and then turn it over to Anna. My thoughts are the following. First of all, Chesborough specifically asked for severance from Powell for exactly this reason, that she's a nut and I don't want to sit at a defense table with her and have the jury assess us next to one another. Because that will taint me. I want to go to trial alone. And that motion was denied, but it has now been effectively granted by dint of this plea. So Chesborough, in fact, gets what he wants. There is no prosecutorial ethics question here, in my view. She was offered essentially the same deal that Hall was offered a few weeks ago. It's clearly also on the table, by the way, for Chesborough, or at least it was, and he turned it down. So they're clearly making something like this deal available to at least the first few people who come forward. And yes, it is a bit of a windfall for Chesborough. It's still nuts, in my view, for him to go to trial, given the disparity in time that he could get if he's convicted of multiple felonies, including RICO, or as Quinta would say, the RICO, than if he were to take this deal. Anna, what are your thoughts?
I mean, look, I think that my gut reaction was to think that, Chesborough might be kind of happy about this. I certainly don't think that, it was encouraged on their part, but I did kind of think, maybe that team will be happy about this. But at the same time, I mean, you've got to realize that, there's a big difference between being severed from someone else's case and then, they plead guilty with an agreement to cooperate with the prosecution. So I think ultimately, all things considered, any of these defendants in a RICO prosecution pleading out and agreeing to cooperate is not going to be something that any of these defendants who are planning to go to trial will feel very good about. And I think that especially, knowing that Chesborough's team had rejected a plea offer previously, I don't know, but I've really got to think that there's probably some discussions going on today with their client about what their next move is, because now that Sidney Powell has pleaded, like Ben said, no one wants to be the last person to plea. And it's better to get in, now while you can before the deals start to get a little bit less sweet. So we'll see what happens, but I'm really curious over the next few days to see. But I don't agree that this is something that they're thinking is ultimately a good thing. But I don't know.
All right. Josh asks, apparently Lauro was not appropriately admitted to the appeals court bar, which came up when he filed the appeal from the gag order. Does this matter? Does anybody know what the DC Circuit's practice is on people who file appeals without having been admitted pro hoc vice to the DC Circuit?
I think it's really I don't think it's a big deal. I think that this is something that happens and all they have to do is file a little form and it's not a big deal at all.
I did look this up before and they sent him a letter yesterday being like, you're not registered. You need to submit an application. There's an application fee of like $238. And then that's all he really seems to need to do.
They've also added a bunch of apparent appellate lawyers. I don't know if that's for this or not, but the Missouri Solicitor General and so on.
All right. Anonymous attendee asks, can Trump's attorneys be held accountable if he breaks the gag order? This is a very interesting question. Normally, these gag orders apply less to parties than they do to the lawyers in question. The lawyers being officers of the court, the court has authority to order them around. Those First Amendment issues are much more muted there. When you are the defendant and you're not there by your own free will, the First Amendment issues are a little bit heightened. That said, if Trump violates the gag order, it will not be his attorneys who are sanctioned for it. It will be Trump. Do you agree with that, Roger?
Yes, and I mean, especially this client over whom no one has any control. And then, but there was also discussion during the hearing about, well, what's going to happen if he violates? And the judge threw some things out. Special counsel Molly Gaston threw some things out. Nobody said we'll punish the lawyer.
All right, anonymous attendee also asks, on a more lighthearted note, any comments about the woman who interrupted and approached Trump during his civil fraud trial in New York? Is this the kind of circus atmosphere y'all expect over the next year plus? I would say yes. Does anybody else?
One word answer. Absolutely. I think in a lot of ways, the civil trial is kind of a preview of what we're going to get. And I am certain that things like this will happen again.
Other thoughts? Okay, Shannon asks, Quinta, have you or anyone else been watching the Eastman Barr hearing? What do you think of his defense? He seems to be doubling down on election interference and his witnesses seem kooky.
So I have not been watching the hearing just because it's been taking a pretty extraordinarily long amount of time, and so I just haven't been able to keep up with it. But yes, it is. The hearing is ongoing. I think they're supposed to wrap up with the hearing soon. I think that Eastman is a good example of the first category of sort of Trump defendants and co-defendants that I sketched out earlier, the people who are really just doubling down and sort of going full MAGA, so to speak. Jeffrey Clark would be another. But Eastman, yeah, is clearly, he's not backing down. He's arguing that his legal theories were merited and certainly should not be subject to bar discipline. So I will be interested to see where this goes, to say the least.
All right, we are now back to Nathan's original question, and I'm going to do this in order. Roger, Quinta, Anna, Hyemin, and I will go last. What leader in history or fiction reminds you most of Trump? Roger.
Gee, I don't have a good one. Some people have told me Berlusconi, but I don't really know enough about Italian politics. Bolsonaro certainly comes to mind. I've been thinking about people in the Dr. Strangelove, but I can't really grasp onto one. And I'm trying to think of my Jerzy Kaczynski novels, but no, I'm afraid I can't pull something out.
All right, Roger goes with maybe Berlusconi, maybe somebody from Strangelove or Jerzy Kaczynski novels. Quinta, what you got for us?
I think it's really hard because he's so sweet generous. So I will give two kind of half answers. One is the first thing that came to mind is the wonderful production of King Lear that was recently in DC with Patrick Page. There's definitely Trump echoes to that. However, I think that Lear has a much more rich and interesting inner life than Trump does. So I don't want to insult Lear by suggesting that there's too much of a similarity there. The other thing is the movie that I think best captures the experience of having Trump as a leader is the wonderful Armando Iannucci film, The Death of Stalin. I am not comparing Trump to Stalin, but I am comparing the sort of chaotic anchorless energy of being in that kind of space where you just have no idea what's going to happen next. And it could be very stupid or it could have enormous importance. And I would recommend that to anyone who is processing the Trump era.
Anna, what's your nomination?
Yeah, I mean, it is hard because I always say that you can't make good art about the Trump era, and because it was just so, and it is just so, I don't know, it's just really hard to make art about it. And so therefore, I'm not really sure that I have a great analogy or answer for you. But I do kind of think that there's elements of both the Wizard of Oz and the Hans Christian Andersen fairy tale, The Emperor with No Clothes. On one hand, Trump is kind of a Wizard of Oz character because he tries to manufacture his own persona and claims to be something that we all kind of know that maybe he's not, or that people eventually discover that he is not. But then on the other hand, there's elements of The Emperor with No Clothes because it's more of like, he kind of in some ways truly does think of himself as this great leader, and it's everyone else who is kind of propping him up and kind of, not telling him or kind of buying into this fiction of what he believes about himself. I don't know if that makes sense. So we're somewhere in between those two things. And I'm not sure which one it is.
All right. What you got for us, Hyemin Han?
Well, I actually did have an original answer for this a while ago because I think that he reminds me the most of the Sun King, Louis XIV, in part because of the whole Guggenheim gold toilet situation and how Louis XIV was really into himself and really wanted to create these very ostentatious things. And so the disanalogy, of course, is that Louis XIV was actually pretty good at his job insofar as he did consolidate a lot of power for France at the time. So maybe it doesn't work completely, but I think that there's an element of egotistical, self kind of creating and self-promotingness that reminds me a lot of Louis XIV with Trump, and also the way that he kind of controls his people, like the way that Louis held court was very thoughtful and manipulative. So I think that he is, for me, a kind of wannabe Louis XIV, a wannabe Sun King.
All right. I will wrap this up with, I think, the definitive answer to this question. Trump is the alien from the 1979 movie Alien by Ridley Scott. Just think about it. It starts by attaching itself to your face, implanting the embryo in your intestines. It bursts out through the stomach of the Republican Party, grows and kills everybody one by one on the ship until the last person standing in a memorable performance of Jack Smith by Sigourney Weaver blows Trump out through the airlock and into space. That is the definitive answer to the question. Watch Alien again. It's all about the Trump era. All right, you have been watching Trump Trials and Tribulations. I want you to, if you are one of the people who's watching on YouTube, come join the conversation in the inner circle by becoming a material supporter of Lawfare and joining us on the in the inner sanctum. You can hang out with Hyemin in the jungle studio with the plush fur rug. We will be back next week, Thursdays at 4. I have no idea what's going to happen between now and then, but I'm excited about it. And we're going to be here.